Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
That's my on the matter of the process for appointment. I think all of that, the questions you asked are in the bill. So I'll share a copy of the bill with you. Yes.
Because my learned senior has raised certain important matters, I think it's important that I intervene quickly to put the fear people have at rest immediately at once.
Thank you.
Very important. Yeah. You see, first of all, the National Democratic Congress, in its 2024 campaign manifesto, which is the social contract we had with the people of this country, overwhelmingly endorsed at the poll, was the fact that we promised that we would put in place a proper mechanism for the establishment of the public tribunals. Consistent with the promise H.E. John Dramani Mahama made to the people of this country, steps have been taken to establish that. Fears have been raised. I've listened to my learned senior Abu Jinapor, and I've listened to Ambassador Michael Oquaye now. Those fears are without any basis whatsoever.
Why do you say so?
Legitimately, you can describe them as red herrings. No basis. Look, I have with me, and because you gave me the topic, prior to coming here, I went for the public tribunal bill. So as to inform the public adequately on what the government intends to do. Let nobody put any information misleading here. The tribunals are part of the 1992 Constitution.
Thank you.
And there had not been any amendment whatsoever till now. In fact, the only time we came close to anything like an amendment was what happened in 2002. That is the Courts Amendment Act 2002, which amended the Courts Act with the removal of the district tribunal only. And that was even in 2002. But the regional tribunal, as established by the 1992 Constitution itself, is still there in our books. The only thing that was lacking is how they will operate. It is that operational mechanism that this bill is seeking to fill and to intervene. And so if you look at the bill, and before the bill, look, like I pointed out, Yebi and Abalifo was tried at the regional tribunal here in Accra. Incidentally, the respected senior state attorney, Anthony Jambibi, he prosecuted that case. And my senior in Krabia Fadate was the lawyer for the accused persons at that time. That was when the NDC reported its missing money. And the matter went to the court. And incidentally, in that case, if you recall, Senior Nkrabia Efadate raised an issue about its jurisdiction, which the Supreme Court had the opportunity to consider. And the Supreme Court at that time, yes, referenced that the regional tribunals, yes, in fact, had jurisdiction to try those serious offenses, even though the money stolen belonged to the NDC. So that record ought to be set. Look, there in the Republic, even robbery were being tried at that time by the public tribunal. Now let's go back to the fears expressed by Marlene Senior. If you look at the public tribunal, the bill itself as we have it, and I want us to go to the proposed section 11.
Section 11?
Yes, okay. Of the bill as proposed.
Section 11
of the proposed. No, this one is the proposed.
Yes, the proposed bill. Yes,
this is the proposed bill.
I just put it all together. Yes, I'll send it to you.
Section 11 of the
2026 Tribunals Bill.
Yes. So, Senior,
do you have it now?
Yes,
I'm talking about Michael Oquaye Jr. Do you have it now?
Maybe I can share with.
We're ready.
I can share with him. So let me just proceed.
Please,
yes.
Go ahead. Yes.
Section 11 of the proposed bill. And just to ensure that everything confirms with the 1992 Constitution, this is what it says. Appointment of chairman of public tribunal and panel members. the fear he expressed relative to the panel members. And see what the bill says. 11.1. The president shall, acting on the advice of the Judicial Council, appoint the chairman of the public tribunal. B, the chairman of the district tribunal. So it is upon the advice of the Judicial Council. So
it's not the president.
It's not a whimsical, capricious. And in fact, this provision is the same as the appointment of high court judges. They basically lifted it verbatim with all the necessary modifications. Now, what happens to the other members, the other panel members, the appointment? That's 11.2. It said the Chief Justice shall, acting in consultation with the Regional Coordinating Council for a region and on the advice of the Judicial Council, appoint panel members of the Regional Tribunal. So where is the fear? Important constitutional safeguards. So the other members of the District Regional Tribunal are going to be appointed through the Chief Justice, having consulted the Coordinating Council of the respective region. That's for the Regional Tribunal. On the advice of the Judicial Council. Fair safeguard. Now for the District Tribunal, the panel members, the same 11.2 now says that when it comes to the District Tribunal panel members, one, the Chief Justice must consult the District Assembly on the advice of the Judicial Council. Just as High Court judges are appointed, Circuit Court judges are appointed. The same procedure had been what? Brought into this public trial. So they fear that maybe some NDC member working somewhere can be picked and put on the public tribunal. That fear is cured in the proposed bill. In this country, NDC, NPP have had even non-party members appointed to the apex courts, Superior Court judges, and they have delivered justice. That had never been a problem.
Because there are guidelines.
Guidelines. You can't act whimsical.
The law is the law.
Well, no. That the last time that phrase was used, it became problematic. No. I would restrain myself. So let me just stick to the issues. So, Section 11 of the proposed bill, which deals with appointments to the regional and district tribunals, have provided enough constitutional safeguards against such whimsical and capricious application of the rules just to undermine. When I listened to my learned senior, Jinapor, it became obvious that as at the time he was speaking, he's not had the benefit of reading the bill. Because if he had the benefit of reading the bill, those concerns would not be raised. What are the fears? He, Abu, at the time he was MP for Damongo, at the time when he was Deputy Chief of Staff to President Nana Addo Dankwa Akufo-Addo, the President appointed a non-NPP person as a Superior Court judge. Was illegitimate. You had confidence.
Right, you want us to remind you of your
No, I'm coming. Don't go there. No, the point I'm making is that, so what is the fear? What is the foundation of that fear? If you go back to the bill, it tells you, and I've spent the whole night combing through the bill just to ensure that we allay the fear of the public. Now, the innovations that I see in this bill, and Senior Martin, with your guidance, if you look, I have some challenges why those particular offenses have been listed. Look, Code of Conduct and disciplinary rules. A member of the tribunal is subject to the relevant Code of Conduct and any other disciplinary rules, just to ensure that they don't misconduct themselves. It's here. Section 14 of the proposed bill. Now, what is even interesting is that the innovations in this particular bill, and for me, the thinking outside the box, is that it says that when this public tribunal is trying a matter, okay, which involves specific, and the law is specific, it says that when it involves minerals and mining, this is how the tribunal should conduct its affairs. Profound. We don't have any such law so far. It says that when you are dealing with galamsey-related offense, and this is President Mohammed's commitment to the fight against galamsey, he said there shall be no stay of proceedings. It's in the law. Look.
Yeah, but
I'm coming, Senior. I'm coming.
The challenge.
See, Session, no, Senior. No, you say Senior. In one breath, please.
Just one
mode of trial. The mode of trial. And then right to legal representation. It says, Section 27(1), a person who appeared before the tribunal shall have the right to be represented by a legal counsel chosen by the person. Safeguard fair trial. Article 19. Here. Application of Evidence Act. The Evidence Act 1975, NRCD 323, applies to proceedings of a tribunal subject to necessary modification. Further rules of engagement. The tribunal may admit evidence whilst ensuring compliance with constitutional and statutory safeguards. Constitutional and
implied.
No, I'm even saying that beyond even the implication, this one is expressly provided for. Further safeguards. Now, another interesting one. Live broadcast of public interest cases before the regional tribunal. Live broadcast.
That is
Section 31. It says, proceeding before the regional tribunal which involves a matter of public interest, including an offense against the state, may be broadcast live. So that if the tribunal members are misconducting themselves, the whole world will see. No secrecy. You can't go and hide.
The courts too.
No. But I'm saying that. So what is the fear?
If at
the end of the day, the whole public will see their conduct. No secrecy.
When the law says may, it is not obligatory.
But I'm saying that. You even want it shall. Very well, very well.
Because of the experience I have. Saying that. I rather will use the word shall to make it obligatory on us rather than may, which presumes that it may be done or may not be done. Because the public hearing is very important. Because these are...
And I strongly agree with him. So that at least the whole public knows what's going on. No kululu, no libilibi, no laba. The other point is that if you look at session, and look, Alfred, I beg you, I'm taking small time because this thing is important that we clear the public conception about the public tribunal because of the misinformation that has been put out. With respect, if you look,
you have your time.
It says defense of accused person and preliminary objection. Just to ensure expeditious trial, it says that a person who wants to oppose a charge shall, within 10 days, so limited time, when the charge sheet is served on you and you have an opposition to it, within 10 days you must file it. What this bill is introducing is speedy trial. So the point where lawyers can deploy all our skills, wait and do, we want to cure it with this one. Now, even more profound is the minerals and mining processes. It says where a party to a proceeding in relation to a matter under the Minerals and Mining Act 2006 is dissatisfied with a decision of a tribunal in respect of an interlocutory application, a party to the proceeding may make an interlocutory appeal against the decision of the tribunal. During the trial, interlocutory appeal shall only be made after the conclusion of the case. So where, for instance, tendering of evidence, you have an objection, you want to appeal, you want to stay. It says those things you can't do it with the public tribunal.
You have to finish the trial.
You have to finish the trial Then if you have interlocutory appeal, you consolidate all of them and you do. That is not what is happening with the current legal regime in criminal trial. Because at this...
Because I have an appeal that
exactly.
been set in 4 months.
And I remember, and I'll tell you, when I did the NCA...
The wheels of justice grind slowly.
No, but when I recall when I was doing the NCA matter, we tendered in evidence and we raised an objection with it. So that objection was overruled, and I appealed it. And I brought a stay application before the Court of Appeal, Koram, Tanko, blah, 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 at that time. They said, look, yes, it's a legitimate basis for an appeal. However, the stay will be refused. This time around, the legislation is trying to cure that whole enterprise where you can only file the interlocutory appeal when the prosecution says we have closed our case, then you can do that.
Also come with time for them to determine the appeal. Because and again,
no, so when the appeal has
not been determined,
yes,
there must be a stay so that
listen. Section 39(3) of the proposed bill says that an interlocutory appeal filed under subsection 1 shall be determined within 30 days.
And shall operate as a stay.
No, this one, it does not. Now, it says that, wait, section 40, stay of proceedings. There shall be no stay of proceedings in the case under the Minerals and Mining Act 2006. So when it is a galamsey-related offense, and the public tribunal is doing it, it says that there shall be no stay.
So how fair is that?
But you see, this is a determination to ensure that criminal justice is administered speedily.
Yes, but again...
These are not legitimate... So I am saying that this bill introduces very innovative provisions to ensure that the things that we lawyers do, basically, you know, there will be a certain
cases,
there will be a certain
Thank you. So let me just make this point. I mentioned here that he was talking about galamsey. And you remember I said one of the things. One second. I need to
I'll come back to you.
I'll come to you. Make a galamsey case. It shouldn't be the case.
Okay, thank you.
And secondly, if we look at this issue of...
You are not on.
Listen, I'll come to look at this 15 days, 10 days matter. Just quickly. We want to understand
my good friend's
better.
Submissions. Indeed, it is important for us to also look at how we stay proceedings when you have filed an appeal. I have already now an appeal at the Court of Appeal that is 4 months, and the Court of Appeal, they have not even settled the records. And in that case, if the proceedings are going, it renders the appeal nugatory because it cannot affect the proceedings. By the time we come back, it will have finished. So much as we want to expedite the trial, let us also make sure that appeals as raised at the end of the close of proceedings of the prosecution be also given time arrangement so that we will come back quickly and then continue. And the clause that says, or the section that says there shall not be a stay, it's defeating the purpose of the appeal. So we should look at that one. Nevertheless, let me go on with my submission.
Understand you MPs, when the thing is still at this level,
yes,
you
so
call it clause by clause, not section. So for now, let's...
my former colleagues to look into this matter, do the necessary debate and make sure that the right things are done. But on my own, let me, my contribution this morning on the bill. Indeed, I'm going to speak as a lawyer without more. So... we go to Article 126 of the Constitution.
126.
126 of the Constitution.
126.1.
126.1.
The judiciary shall consist of...
And for purpose of time, let's go to 126.1 AIII. So the judiciary shall consist of...
The High Court and regional tribunals.
Shall, and the word there is shall. Mandatory. So that... it is the word tribunal that is agitating all of us. But again, in our constitution, it is so provided that it shall. So it is even late in time, because the constitution having given us this order, we ought to have done it even before now.
It was there. We just stopped.
But you see, I'll come back to that. I'll come back to that.
You know, the 2002 legislation actually proscribe it.
No, the regional tribunal.
No, that one there was never. It was the district.
And you go to Article 143. A regional tribunal shall have jurisdiction to try such offences against the state and public interest as Parliament may by law prescribe. So the expectation is that Parliament will bring out another law that will guide the performance of the regional tribunals. And in fact, the regional tribunals are given specific roles, not general jurisdiction as pertains in the district court
specific.
or the regional courts. But by the Constitution, is given a specific assignment. And that is why maybe reference is being made to trials under minerals and mining law.
And in fact, that section 11 that Edudzi Tamakloe read in this particular bill,
Clause 11.
That's clause 11, is captured in Article 1443.
Yes.
Justices of the Court of Appeal and of the High Court and chairmen of regional tribunals shall be appointed by the President, acting on the advice of the Judicial Council.
So let's not even go into it. But let's look at the constitutional provisions. And again, Article 143 says that regional tribunals shall have jurisdiction. And you see, when the Constitution or the law says shall, it means it is foreclosed that it must happen. So for me, the matters of its establishment is a constitutional matter. Whether or not we like it as a state or as citizens or as Ghanaians, we may have to, then repeal those clauses of the Constitution, amend by way of amendment, amend the Constitution. But again, don't let us also forget that these are entrenched provisions, that it cannot be amended as of right of Parliament or any institution. It must be by referendum. Absolutely. You see, so if we want to amend a constitution as it speaks like this, then we must go through the process of amendment, and then we take it out. But not until that time. The constitution is ensuring that we do it. So if we want to do it now, I don't think that, for me, it is not unlawful. But if we are not happy with the situation, then we must go through the process of changing the provisions on the law. But given this opportunity to affect the legal system through the Constitution, let's look at Article 139 2D. And it says that the court shall consist of 139 The High Court shall be constituted by 3 judges of the court for the trial of offences of high treason or treason as required by Article 19 of the Constitution. So it says that the High Court can try treason and high treason. Now go to Article 143. The High Court shall have no power in a trial for the offence of high treason or treason to convict a person. You see, the same Constitution contradicting itself.
So what's the point?
You understand? So what I'm saying is that these two laws are contradictory to each other. And therefore, in the hierarchy of norms, when there is a provision that comes against another provision in the same law, the import is that the first one gives way to the second one.
Because and the whole idea is that the legislator knew of that before introducing.
Yes. So the first one will give
more or less to cure a mischief earlier.
So I am saying that this constitution, as you have it, has these two provisions contradicting each other, and for which reason it retires Article 1392D as non-effective.
All right.
And therefore we will go away with that. Now, coming back to the tribunal system and the fears as expressed.
And the fears, yes.
The fears regional tribunal. Yes. Because it's a constitutional expectation, we cannot fault it. But that is why there's a requirement of Parliament passing a law to effectuate the provisions under the Constitution. So Parliament has a duty to ensure that all the safeguards that will cure the fears of the public, and in this case, minority, make sure that these provisions are provided to cure.
And I think that they are already there.
But like I'm saying, no. It will be subject to debate. Listen, it will be subject to debate. But as Martin said, they are not sections of the law. They are there is only a bill there. So these clauses are only clauses to be debated in Parliament. So I will urge all of us to follow the debate critically, particularly members on the Constitutional and Legal Affairs Committee. They must show presence and do the debate. And again, when it comes to the plenary, the minority who have various issues with various clauses must be there and debate it and make sure.
But even before this bill is passed by Parliament, that fear of government or the NDC appointing its people on the panel to, as it were, prosecute opponents, is that fear not addressed already in the Constitution?
Well, they are not law yet.
No, I'm talking about
so
the
you could still have the fear.
No, I'm talking about the Constitution.
Okay.
Because if you read 1252, it says citizens may exercise popular participation in the administration of justice through the institution of public and customary tribunals and the jury and assessor system. 1443 says, 1444 says, panel members of regional tribunals other than the chairman shall be appointed by the Chief Justice in consultation with the Regional Coordinating Council for the region and on the advice of the Judicial Council.
Yes, so the provision is there already. So this is the provision that is being lifted into the new act.
So is there any basis for the fear that only NDC people will be appointed on the panel?
Well,
based on this particular provision I just
You see, unfortunately, sometimes when we start the debate without having gone through the existing provisions, because some of these acts, the sections in the act are provisions in another law having been lifted and positioned there. So if we are not challenging the existence of these provisions in this superior law, where is our mandate to challenge it in the lower law? The act is a lower law to this one.
Thank you.
So what I'm suggesting is that let's go in there, do the necessary debate, make sure the right things are done. But the institutions that are going to be created by this new law, let us see also that these institutions work to perfection.
Thank you. The minority in Parliament this week opposed the reintroduction of tribunal courts, arguing that it could become an avenue, one, for creating jobs for party loyalists, to jail opponents. But remember, this is a manifesto promised by the NDC. And not just that, the Attorney General, Minister of Justice, Dr. Dominic Ayine, has been quite clear about the objectives for this particular path that this government is taking and what it intends to achieve. I want us to take a listen to the point of opposition by the minority, as was led by Samuel Abu Jinapor in Parliament earlier this week. And then I'll come to my panel. Take a look.
Why additional courts? Mr. Speaker, with the greatest of respect, why do we like to create new institutions every now and again? We have high courts. Why have regional tribunals? If you want to have more courts, you want to have more judges, you want to have more judicial staff, just follow up with what President Akufo-Addo did when he built almost 100 courts complex in our country. Build more court complexes, recruit more judges, recruit more judicial staffs. And if you want a jury system, let's have a jury system. Mr. Speaker, I don't want to believe this is job for the boys. I don't want to believe that. I don't want to believe this is job for the boys. It shouldn't be. And Mr. Speaker, the point, I don't want to believe that we want to recruit some lawyers from certain courtesses and make them chairpersons of regional tribunals and get 2 people to become members of regional tribunals and get jobs and have some with Mr. Speaker, with respect, some kangaroo system where opponents of the administration will be run through a certain judicial system and jailed. We don't want that. Let's have the existing court system. Let's have the district magistrate court, the circuit court, the high court, the court of appeal, the Supreme Court. That is the judicial system in all civilized, developed countries in the world. We do not want regional tribunals. They bring about bad memories, scary memories, and bad dreams and intimidation in our country. Let's reject it. I thank you, Mr.
It says nightmares, bad memories, bad dreams. But this is the objective for this, at least that's what's captured in the NDC manifesto. And with paraphrases, fast-track justice, the tribunals designed to speed up prosecution of state and public interest cases, Galamsey, others, anti-corruption focus, serve as an alternative tool to aggressively tackle corruption. And then the NDC states that this plan fulfills Article 125 of the 1992 Constitution, which allows citizens to participate in the administration of justice. And this is the position of the minority rejecting this particular matter. Why does tribunals bring bad dreams and nightmares? Michael Oquaye Jr.
Oh, my brother. You know,
why?
This is a topic that I want to take a bit of time to delve into.
Within the time allotted to you.
Yes, and time that will steal from one or two other panelists. But public tribunals in Ghana. Let's quickly go back to 1992 when the Constitution was being drafted. And I'm happy, I'm not sure, but Martin Kwebu, he looks young, but maybe he's 50 plus. I don't know if he is. But as for Apia Kubi, you remember, you know, of course, when the proposals came from D.F. Anand, one of the things that was missing was tribunals. And President Rawlings kicked a fuss, a big, big fuss. In fact, it came into the press. And you remember, a lot of Ghanaians today, the President Rawlings that they know today, the lovely politician who developed by 96 to 2000 and especially afterwards, was not the same man that we are talking about in 1991. What Rawlings wanted, he got. And in fact, at that time, one of the things we were trying to do to please was to get the Constitution no matter what. But in fact, one thing I'll give President Rawlings for credit for is that he kept to his word of not using tribunals. Even though it was in there, he never referred any matters for tribunals to be established.
Which one? Under the Constitution?
Yes, under the Constitution of 92.
No, Yemi Anabalifo was the original tribunal.
I even came and met some practice.
I'm saying that when Rawlings put it in the 92 Constitution, between 92 and his departure in 99, one of the things that he didn't what I'll say, propound were regional and public tribunals.
No, he did.
Oh, he did. But there's someone money. That's a Yedi Anabalifo.
Yes,
That's
an exception. I'm just talking about the fact that.
So I'm trying to connect it to Rawlings.
No, you're making
the. Someone is watching.
Yes, they are not getting. And
the fact
remember,
the case is that
one was used as an exception. I remember very well how it was criticized and never catched. But what I mean is that Rawlings did not attempt to establish them as part of the system, even though it was used.
He appoints judges. Okay, move on to different.
No.
Because the chairman of the tribunal is appointed. He's a high court judge appointed by the president.
No, but we are talking this time of the three and the other appointed ones.
Yes, it's appointed by the president.
But no, that's what. But what I'm stating is that even he, Rawlings, who was what I would call Mr. Tribunal, did not make it part of the system like it's being proposed today. No, and why is that? No, why is that?
That's not an argument. That's not an argument.
No.
He didn't make it a part of the system.
He appoints the chairman. He's equivalent to a high court.
That's why I want to understand.
My point is simple. Yes. As of now, what President John Mahama is bringing up is basically to establish this. And you know, one of the things that has brought this to make it an establishment is matters like Galamsey. And also the fact that they are telling us now that they are going to have this regional tribunal system because of things like delay and things like, what do you call it? Our three-member panel who is going to be appointed not by the Chief Justice, not by the judicial system, but by the President. I insist on...
Have you seen the draft bill?
You see? The draft... What does the draft bill say?
No, you see, because this...
what does the draft bill say?
Public... Okay, no,
you ask a question.
Exactly.
Sorry.
What does the draft bill say?
Have you seen the draft bill? Then
no, but you let him finish.
No.
You see,
no, would help. If you had, then...
One thing that we need to be very clear about, whether from Article 125 and all the rest that deals with public tribunals, regional tribunals, and all the rest of it, is that we have to have a nation where, as the English courts say, you are tried in the ordinary courts of the land. Simply by the fact that you go from the district court to your circuit court, to your high court, to your appeal court, and then you move on to the Supreme Court. What I was saying that you are not understanding is that even Rawlings, he did not go ahead to bring what is now being laid before the Legal Parliamentary Affairs Committee, which is the Tribunals Bill, which is what is being sought at the moment in Parliament. That is the Tribunal Bill of 2026. Under his time, there was no Tribunal Bill that was brought for it to be used. And I'm saying that now it is being legitimized by an act of Parliament, which in itself will then create a whole difference. That's what I was talking about. So I'm saying that, what I'm saying is that even under him, who is Mr. Tribunal, he did not attempt to pass any bill under Parliament. And this is what has generated not just this controversy, but this discussion. And we are saying that the purpose of this bill is to reduce pressure on the regular courts. And we're also saying that this is to speed up the disposal of certain cases. I have lived in a different jurisdiction of legal reputation and also of the Commonwealth, which is India. One of the solutions they have, you know their population, they are 1-point-something billion compared to Ghana, where we have about 32 or so million people. They have a double track court. They have a morning judge, they have an afternoon judge in the same system. And my point again is that why is it that now we are trying to pass a bill for tribunals to become actually a stated and part of our system? And that even he, Rawlings, who was Mr. Tribunal, did not pass any bill. Yes, that exception was used and so on and so forth. But my point is that President John Mahama, why? If there's a certain justification for a certain error, then we have to look at it and say, okay, why do we want to justify this case? What is the exception here? But we can't have a bill of parliament or an act that would make this the standard that we're looking at. Because you see, the constitutional question is complex. The 1992 Constitution recognizes, as I said, the use of tribunals in its sense, lying there.
Okay.
But what we also must know is that tribunals are also not necessarily automatically democratic, or they are not automatically something that we want to see as an ordinary way of judicial dispensation, because the interference is too much. Who are these three panel people going to be? Who are they going to be? Because they are not necessarily all going to be judges. These are members of all walks of life. If the president is the one who is going to appoint them, or at least the lead, we need to know what is the process. If it's not the president who is going to appoint them, we need to know who is going to make that appointment.
But is the process not already outlined?
No, I'm just saying that it's at the moment it's up for it's up for consideration by the Legal and Constitutional Committee.
Precisely.
And these are all things that will come out. I'm not a member of parliament, so I like to ask questions. And then if the answer is here, by all means, let's be educated. But we must ask the questions so that we understand the composition of these three panel members.
Okay.
How is it going to be done? And what is the way that this is going to have? And let us not beat about the bush. What Honorable Abu Jinapor said, and my own self. I mean, tribunals give some of us nightmares. Serious nightmares and worry.
What nightmares?
About, you may not be having nightmares, but I have nightmares of how memories of the past, of some of the acts of these tribunals. So I just think that the best alternative, honestly, and this is my humble opinion, we must look at how we can improve the existing court system. We need more judges. We need to be able to get some digital case management. we should have specialized commercial and small claims courts, because these are things that would help in that regard.
Okay.
We must have stronger legal aid, for example, alternative dispute resolution, and the better resourcing of our district and circuit courts. Because when we have these reforms, these are things that would not create the kind of impression of tribunals, which is of a total dispensation. And as I mentioned before, and I want to reiterate, brings us nightmares in this country. Let us look at these reforms and make more courts. Let us build more courts. Let us get more judges so that we can dispense justice in the two things that we're worried about. One, speedily, and also at the expense that we've been talking about. Otherwise, tribunals is something that is going to become a nightmare indeed.
Whenever I say PENDREAM TV, PENDREAM TV, dear, I see them, you